Hello, everyone. Welcome. My name is Emma Smiley. I'm a supervising attorney with Legal Aid in North Carolina's Disaster Relief Project. And I'm here today to talk about ownership issues and how to prevent them from standing in the way of receiving disaster relief funds if your home has been damaged in a natural disaster. So a couple of disclaimers. I am a lawyer, so we got to go through these. This presentation only applies to North Carolina law. If you happen to be watching from another state, this does not apply to you. This presentation is not legal advice. So if you have specific questions, while you're welcome to enter questions into the chat box, especially if you have general questions about this information, but if you need specific advice about your situation, please contact us. You'll see at the top throughout this presentation the phone number for our helpline and also our website. You can apply for services either by phone or online. And for eligible clients, all of our services are free. So please do contact us if you have a legal issue that we may be able to help you with. All right, so if your home was damaged by a natural disaster, you may be seeking government or nonprofit assistance for repairs to your home. This presentation is not going to apply to you if you are receiving enough funding from your homeowner's insurance to be able to repair your home. So a big question that any government or nonprofit organization that helps people with home repairs is going to ask is, who owns the home? And generally, in order to be able to get assistance, you need to both own the home and live in the home. Obviously, government funding and nonprofit funding is limited, and that means that these organizations want to give that money to people who have fewer resources, who are living in the home as a primary residence, and who are the owners. So if you are a tenant, then you are not responsible for repairs to the home. And so you wouldn't be able to receive home repair funding from government or nonprofit sources. That's your landlord's responsibility. Now, let's say you own the home. I am a lawyer, so I'm always looking at, well, how can we prove that? And one thing that I want all of you to know is to be prepared in advance. Be thinking about this in advance. If you get a home, you buy it, a family member gives it to you, make sure that you're filing your deed with the Register of Deeds, or if it's a mobile home, you're filing your type way. Don't wait, you might lose it. If it's destroyed and nobody else has a copy, then you may not be able to show that you own the home anymore. And if you don't file your deed, you could also be a victim of fraud. The person who sold the property to you could turn around and sell it to somebody else. If that person files their deed first, now they own it. So make sure that you're always filing these things right away so that you'll have that paperwork with the Register of Deeds, with the DMV, when you need to prove that you own your home. Make sure too that you get everything in writing. So one thing that we see is that people are transferring property around in their families. And family members get along, they trust each other, that's great. But living on name is on it, that's not actually enough to make you the legal owner. So you actually do need that deed or title in your name to be able to show these organizations that you're the owner. Now, a lot of people ask, well, what if the property taxes are in my name? Does that make it mine? That's usually not going to be enough. So for FEMA, property taxes may be enough to prove ownership, but for most other organizations, you actually do need to prove through a deed or a title or some other means that you're the owner of the home, and not only that you have taken responsibility for the property taxes. All right, so what if you're watching this presentation and you're thinking, well, my home was already damaged, so I can't solve this problem now. It was damaged in Hurricane Florence, but can I fix the problem now? My brother intends for this to be my home, and he says he'll sign it over. Can you just do that now? And what I want you to do is talk to a lawyer before you do this. Some of them want the person who's getting the funds to have been the owner at the time of the disaster. And so before you start shifting property around now, if it's already been damaged, please talk to a lawyer who has some experience in disaster recovery. Please call us or contact us on our website, or talk to somebody else who's going to be able to help you with this. It may not be too late, but you want to make sure that you get everything right. So here's another big question. What if the person who had the last deed to the property is deceased? Can you now go down to the Register of Deeds and update the deed and say, well, the property last belonged to my dad, he passed away, so now it's mine? And the answer is no. Deeds can't be updated. A deed is what transfers the property from one person to another, and only a living person can sign one. So the good news here is that you don't actually have to have a deed where land has passed from one person to another through inheritance. So if your dad died and you're his child, then, and he didn't have a will, then at the moment that he died, without any paperwork, that property became your property. Now, of course, our question is going to be proving that and figuring it out. What if it's not just you? What if there's other family members too? How do you know who owns the property? There's a couple of answers to that. The first one is, if the deceased person had a will, then they might have named one person, or they might have named several people in their will as the people who are going to inherit their property. So that person or those people are now the owners. The more complicated situation is where there is no will. Law sets out who will inherit your property. And what the law tries to do is give property to the people that the law presumes you would want to give the property to if you had a will. So if you don't have a will, your property doesn't go to the state, but it is going to go to family members who are set out by law. And that's true regardless of what your intentions were. So let's say we've got a mom, she has 5 kids, 4 of them have moved out of state, and Jimmy has been living in her house for the last 40 years. And she tells all the family, this house is Jimmy's house. When I die, I want it to go to him, and all of the family agrees. Everybody thinks that's appropriate. But if she never writes that down and never does a will, when she dies, that's not just Jimmy's house. That's now all of the kids' house. So it's not about what the person's intention was. It's about what they actually put in their will. And if they don't have one, then the law is going to step in and give it to the people that the legislature assumes that the person wants to give their property to. So let's look at a couple of examples of what that looks like. All right, so here we have a situation where the mom owns some property, and let's say she owned it before she got married. She has a husband and she has 3 children. So she's the owner. She passes away. By law in North Carolina, all 4 of those people are now owners together. So some people might think everything goes to her husband. That's not true. The children also get property. Some people might think it all just goes to the children. That's not true either. So now all 4 of these people own the property together. All right, I want to look at another example that's confusing for a lot of people because sometimes people think that there's something special about the person that the property starts with. And that's not true. So here again, we've got a mom who owns some property. She's not married, but she has 2 children. She passes away. The property now belongs to her son and daughter property. Now, when the daughter passes away, who do you think the property goes to? Daughter has no kids. She's married, and he has 2 kids, but those are from another relationship. So her property is going to go to her husband. Now, note it's not going to her brother. So the husband's not related to the mom, but he is his wife's heir. Now, let's say the husband passes away. Again, his property is not going to his brother-in-law. It's going to his children. The son owns the property along with his sister's stepchildren. A lot of people in this situation and in the son's position would be saying, wait a minute, those kids aren't related to my sister. They're not related to my mom. How can they inherit the property? And the answer is you have to go through this step by step and look at each person who was an heir to somebody else. So there's nothing magic about the last person who was on the deed. There's nothing saying that everybody else who inherits the property once she dies without a will has to be related to her. Each step of the way, it can go to somebody else. So a lot of people are going to look at this and say, well, I don't like that. That's not what I want to have happen to my property. How can I control that and make sure it's not what happens? And I suspect you could guess the answer here. Contact a lawyer, write a will, make sure that your will covers who you want to have the property. So let's say you're in talked about. So
Emma,
what does this mean for ownership of the property?
Hey, Emma, your audio broke up for 1 second. Do you mind starting at the beginning of this slide again? I'm sorry.
Yeah, so let's say that your home is heir property and you own it along with some other relatives or non-relatives, as the case may be, as we just talked about. So what does this mean for you and your ownership of the property? First of all, everyone who inherits the property is an owner. You don't just have life estate or what people call lifetime rights. You are a full owner of the property, just as if you and all of these other people had gone to a realtor together and decided to buy this property. That means you can sell your share. You might have a 10% interest, a 2% interest in this property if there's 50 other people. You can still sell your part of it. You can pass on your share to your heirs. You can pass it in your will to whoever you want. It doesn't have to be family. You can give it to your friends. You can give it to the animal shelter. You can give your share to anybody. You can use the property. You can make changes to the property. The catch is that so can everybody else who owns it. So you're all owners together. Nobody really has the right to keep anybody else out of it. So a question that some people have is together. And the answer is typically not. So all of the owners have the right to use the property. Other people who also own it can't just show up, change your locks, kick you out, call the police, move in themselves. You have the right to be there if you are an owner. The only way that somebody might be able to get the other heirs out would be filing a court action for what's called partition. And this forces the property to be sold at a public auction. So heirs can bid and so can other people. Any members of the public could come and bid for this property. And then the highest bidder is going to get it. So short of a partition, everybody's just going to keep owning the property together unless people decide to sell or give their shares to somebody else. All right, so some questions that people sometimes have about heir property. What if you're the only person who lives on the property? People like to say possession is 9/10 of the law. That's not exactly true. So if you are the only person living on the property, like we just talked about, your family can't come and kick you off, but that doesn't make you more of an owner than your family members. That just means that you have the right to live there and you are living there. But they're still owners, and they're still just as much owners as they would be if they were living there and you weren't. So what if you're the one paying the property taxes and all of the bills? That also doesn't change ownership. You might be able to go after those people for contributions to the upkeep of the land, but they're still owners, even if they're neglecting the property and you're the one taking responsibility. So what if the other people have nothing to do with the property? You don't know where to find them. You're not even sure who they are, where they are. Also doesn't change ownership. These other people are still going to be owners of the property. So what can you do if you're in this situation? First of all, you're going to need to figure out who all of the owners of the property are. And this may be easy if it was something that you inherited from a parent and all of your siblings are still living. In some cases, the property may have gone through a few generations and it becomes very complicated. So sit down, draw a family tree, find out if anyone who has passed away left a will, and list all of the spouses and children on the family tree. And then what you're going to want to do is ready.
Emma, we're having an audio problem again. Do you mind repeating back, I think your step 2? Sorry.
Yeah. So I'm sorry, it seems like we're having some audio problems, and I'll see if I can get a better internet connection here. But once you have your family tree together, what you're going to want to do is talk to a lawyer, talk to each other, figure out what the plan is for the property. Some people may really not want anything to do with it, may be happy to sell or give their shares to others. Short of partition, there's not really a way to force people to turn over their shares if they don't want to do that. So you're going to want to talk to a lawyer to figure out, once you've got the family tree, which of these people are heirs, and then figure out what you want to do with the property. So back to now, you can see that this can be complicated. There may be a lot of people involved. Not everyone may agree on what they want to have done with the property. Is this going to stop you from getting disaster relief funds to repair damage from a natural disaster to the property? So you can still get disaster relief funds, but you're often going to have to do more paperwork than you would if it was a straightforward situation where you had a deed or title to the property. So do your relatives have to?
Emma, we're having another audio problem. Do you mind starting over with the question?
Let's see. I'm sorry, we seem to be having some connection problems here. So you likely will need to get any other owners of the property to sign consent forms for the repair work to be done. That's not a legal requirement. As an owner of the property, you can have repair work done without needing to get permission from other owners. And if you're spending your own funds on it, you can certainly go ahead and do that. But what we have seen is that most government or nonprofit sources will want signed consents from all of the other owners as well. So if you have any of these issues that we have been talking about today, or if you have any other 66219-5262. Thank you for being here. If you have any general questions, please feel free to leave those in the comments. We'll do our best to answer them. And if this situation applies to you, please do give us a call. All right, thank you.